So here at Cookman Law, my team and I receive a lot of questions about how estate planning works. Some are more about the types of documents that people need, and others are questions that people are a little bit shy or hesitant to ask. But definitely there are some common misconceptions out there. Maybe you've heard that your assets will automatically go to your kids when you die. Unfortunately, this isn't necessarily true. Or maybe you've heard that when you die, if you don't have an estate plan, the state gets all of your assets. Fortunately, that one's not true either. Today, I'd like to go through some of those questions and the answers to clear up some of those misconceptions that are out there. My first two questions are all about taxes. So some people think trusts are not subject to estate taxes, or they might think trusts protect you from estate taxes. This just isn't true. Trusts are really tax neutral. If you put something, and it depends on what type of trust really. We're talking about revocable living trusts here. If you put an asset into a revocable living trust, that's tax neutral. That counts as your stuff. You report it on your own 1040 income tax return. So it's not protecting for income taxes. It's not protecting for estate taxes. Now, there are some tax structures that you can use to provide some protection for estate tax planning, like an A-B split. And I do have a video about A-B splits where half of the assets can be protected for estate tax purposes. But generally, revocable trusts are used to protect from probate and also for good management and control. Another misconception is that I have a lot of people coming in and saying, "Hey, Ellen, I need your help in protecting from death taxes." First of all, you might be thinking, what are death taxes? Well, death taxes are basically estate taxes at the federal level and at the state level. In California, where I practice, there are no state estate taxes, but in other states, there are some. But really what we look at is federal estate taxes. Right now, a person can protect up to $13.61 million per person. So for a couple, it's over $27 million, or just around there, and not have to pay any estate taxes. But that amount is dropping in 2026 to about $14 or $15 million per couple, or about $7.5 million per person. So if your estate is larger than about 15 million, then you should be worried about estate taxes. But most of the folks who come to me do not have that size of estate, and they don't have to worry about death taxes. Now, I think that politically, this has been called death taxes because politicians want you to think that estate taxes apply to everybody. But no, it really only applies to the most wealthy of us, and most people don't have to do planning for that. The third misconception comes up for couples who are not married, but they figure, okay, we've been living together for a while. Now, common law marriage applies to us in California. Well, I have to let you in on a secret. There is no common law marriage in California. It's just not a thing anymore. There could have been a long time ago, but it has not applied for a while. So if you're living and you're not married, then you have separate property, but there's no presumed community property. Now, with that being said, it might be true that maybe you've made a verbal or written agreement that one person will take care of another person or get some equity in a home by helping to pay a mortgage, that sort of thing. So there could be some joint assets that if you break up, you'd have to go through to see, has a contract been created? But as far as family law goes, if you're not married, you're not married, and there shouldn't be any common law marriage. Another misconception is that once I'm married, everything that I bring into a marriage automatically becomes community property. Now, this just is not true. What you receive before you're married, like if you work while you're single or you receive an inheritance or a gift, and then you get married, everything that you have that's separate property remains your separate property. However, once you're married, you can opt or choose to transmute or mix your property. So let's say you have a house that's your separate property. Once you get married, if you add your spouse's name to the deed, you have transmuted that. You have changed it into community property. But that takes an actual extra step to change that. So if you come into a marriage and you have separate property, it's held in a trust, and you're not putting community property assets in it, that remains your separate property, and you can do your own planning for that asset. You don't even need to have the cooperation of your spouse. You get to decide what happens to your own separate property. Now, I did a video with family law attorney Lydia Shu, and we covered a lot of these family law issues. I recommend that you take a watch to see answers to these questions and many others. Okay, so let's cover the questions that I raised at the beginning of the video where people believe, hey, everything just goes to my kids automatically when I die. That's not true. First of all, we have to determine who are your kids. And there could be some other people who come out of the woodwork who claim to be your kids, but they're not. Or maybe they are. I don't know, right? So if you don't have a trust, a revocable living trust when you die, everything's going to go through probate. And if you don't even have a will that says where you want things to go as it goes through probate, it's going to go to whoever it says it should go to in the probate code. Now, the next question that I get is, well, is it going to go to the state? No. In the probate code, it doesn't say it just goes to the state. That doesn't happen. However, you do need to look in the probate code to see where it does go to. You might have a child who's estranged from you. That doesn't matter. In the probate code, it says that part of your assets go to that child. And community property is treated differently than separate property. It's all spelled out in the probate code, but it does have to go through the court system. So things probably will end up with your kids, but in a long and convoluted process, which you'll want to avoid.
Hey everyone, if you like my mom's video, like and subscribe.
A couple more misconceptions come up when it comes to nominating guardians. One of them is, well, I've named godparents for my children. They'll just take over raising my kids when I'm gone. Now, that's a problem because even if they're godparents, they don't have the legal authority to make decisions for your children. If you die and you have minor children, then there's going to be a guardianship process where somebody goes to court and petitions to be guardian for your children. So that could be the godparent, but it also could be a sibling of yours or could be the child's grandparent. So just being a godparent is not sufficient to establish that that's who you want to be the guardian of your children if you're gone. So you really do need to put together guardianship nomination forms. And in that nomination form, you'll say, who do you want to act as guardian of your children when you're gone? You can even spell out the reasons why. And then that can be used by the proposed guardian to show, hey, this is who the parents wanted, so judge, please allow me to be guardian. Now, that leads to the next misconception that, of course, I can choose who's going to be guardian, right? Well, you get a say in the matter. But as I mentioned with that last misconception, when you're dealing with minor children, it always goes through the guardianship process. So you're always going to have somebody petition the court, and the judge looks to make sure that the person you've nominated as guardian is really the right choice, that they haven't moved to Timbuktu, they haven't become drug addicts, they're still alive, they still have full capacity, that your children are okay living with them, because the kids get a say in the matter too if they're old enough to express their wishes. It's not like a trust where you have a revocable living trust and you name who's going to be successor trustee, and definitely their successor trustee. With guardians, and also conservatorships, by the way, you're nominating who you want to be the successor guardian, who you want to take over raising your children, but then the court is the one who's going to rubber stamp that. They have to approve who you've chosen. The last two misconceptions really have to do with having an estate plan in general. So some people say, I don't need an estate plan because I've already told my family how I want stuff to be divided. And that's good enough. Well, here's the problem. An oral expression of what you want does not create a contract. That's actually called the statute of frauds. That means you need to have a written contract in order for it to be effective. So even writing, I don't suggest this, but even writing something down on a napkin is more valid than having an hour-long conversation with somebody, because that somebody who you had a conversation with, who knows if they have the correct recollection of what you said or not. It can lead to a lot of fights if you just leave the money and then just say, all right, you guys sort it out. If you care about your family, which I'm sure that you do, you will want to write out your wishes. So then they can just follow the wishes, and that just avoids tons of fights. And then the last misconception or just statement that I think is wrong is when people say, you know, I don't care what happens at my death. I don't care if the government gets it or court gets it or if my family gets it. I'll be gone. I just think that's a very shallow way of looking at things, because there's a lot of people out there who could use the funds, and if they have any sort of claim to it, they're going to be fighting over it. So I encourage you just to keep the peace. Write down if there's a charity that you really like, name them as the beneficiary. Then you know it's going to go someplace that you approve of, and it's not going to be caught up in litigation hell for years upon end. You better believe that people get along nicely with you when you're alive, but when you're gone and there's money involved, that's when the knives come out, right? And for more on this, I suggest that you watch my video, 7 Ways to Keep the Peace After Your Death. So hopefully this has cleared up some myths about estate planning. Now, if you'd like to be added to our firm's mailing list, where we're always sending out accurate, non-myth information about estate planning, you can click on the link below in the description section. Thank you so much.
Hello everyone. If you liked my mom's video, don't forget to like and subscribe. See you all next time.